A promise of my honor to be faithful and loyal to Ghana, my motherland. I pledge myself to the service of Ghana with all my strength and with all my heart. I promise to hold in high esteem our heritage, won for us through the blood and toil of our fathers. And I pledge myself in all things to uphold and defend the good name of Ghana. So help me God. So happy Independence anniversary to all of us. And we couldn't join the national celebration, but we were able to celebrate it in our own way. So this morning, we are going to do a couple of things in our civil procedure. The first segment of our discussion, we will go back and discuss applications and affidavit consistent with the set manual or the syllabus. Now, when we are done with that, we move on to our next major segment, which will be pre-trial proceedings, where we'll be discussing issues relating to interrogatories, discoveries, admissions, application for directions, case management. And if we're able to make more time, then we will probably move and discuss commercial courts so that next week we can start discussing of a trial and related matters. So those are the things that we propose to do. In order to ensure order, I have locked the mic, but if you need to, actually, if you need to talk or anything like that, just raise up your hand and then I will allow you to talk. So we are first of all going to understand the whole point of applications within the civil procedure or civil litigation or civil justice scheme, and how applications are made, the various types of it, and we will quickly revisit affidavit. Of course, we've discussed these things already, but because I am just following the path in the manual or the syllabus, that is why we are coming back to them again. So I'll move very fast, assuming or taking for granted that this is something that we know. So first and foremost, when we talk about applications, we should note that applications are, I should say, the heartbeat or the engine room of civil litigation, because we have pleadings. We know what pleadings do. Pleadings define the dispute or the controversy between the parties. But ultimately, it is applications which regulate procedure, so to speak. And again, we have noted that most cases, most civil litigations are decided not only by final judgment. Some are even decided more or less through what we call the interlocutory applications, as it were. So therefore, interlocutory applications would even let us know the evidence ultimately, which will be alleged during the trial, the timelines, whether they are kept or they can be varied, issues of compliance with what is expected in terms of pleadings. Can they be strike out? Summary judgment, stay of proceedings. These are all matters which you can achieve by making use of applications. So applications are very important. And that is why if you read my teacher, Mr. Kwame Tete's work, the civil procedure, in chapter 16, for example, he will tell us that applications are the procedural instrument through which litigation strategy is executed. Litigation, as we have seen, whether you like it or not, is like a battle, it's a contest. And because it's a contest, you must have a strategy. Every move counts. And the move will be made through the instrumentality or the framework of applications. Order 19 governs applications and Order 20 governs affidavit, as we know. And so first and foremost, an application may be understood as a formal prayer. If I say prayer, I'm not talking about the prayer we make to God, like a request. So it's a formal prayer or request to the court seeking specific relief within the context of an existing action. So the application we are talking about, of course, we are also mindful of what we call the originating motion or notice, which is also a form of application, which actually begins an action. But that is not the emphasis this morning. The emphasis this morning is application within the context of an existing action. There's a pending action, and out of that, you make certain formal requests, certain formal prayers to the court. So application may seek maybe procedural directions. Sometimes you don't even know what to do next. You may want to go to a court for the court to actually give you directions as to what should be done regarding the next step of the proceeding. So you go for direction, or you make application for interim protection. Sometimes it is necessary for the court to give you certain protection or some kind of a relief before the ultimate decision is made. That is the rare judgment is made at the end of the case. So you need some interim protection, as it were. Or you may even be challenging jurisdiction. Either the court does not have jurisdiction or the jurisdiction of the court is not properly invoked. And all these things, you have to bring it to the attention of the court through application. And in some cases, you may even need a final relief. You can have like a very short-circuited, if you like, a relief through summary judgment, Order 14, as we have seen. Summary judgment, you cannot achieve it unless you have an application. So applications are very important. So therefore, quite apart from what we call the originating motion or notice, originating application, which is separate, like where you used to commence things like maybe enforcement of fundamental human rights or matters from the company law, right, Companies Act, or maybe some other enactment which says that you may bring an application which is originating motion or notice. That is different. That is what we are talking about this morning. The emphasis is mainly on application in an existing suit or an existing litigation. Yeah, so quite apart from originating motion or notice, applications are not independent actions. They don't stand alone. They are ancillary to pending proceedings. So the pending proceeding is the main thing, and applications are just, if you like, appendage or ancillaries to that. So let's keep that in mind. And again, applications actually bring three things to the fore. Party initiative or party autonomy, because application is one of the parties who is moving the court or bringing something to the court. So you are taking the initiative. Again, a lot of applications too are based upon judicial discretion. It's not for asking, it's for the court to decide whether what you're asking for should be granted or should not be granted. And for that matter, there's an issue of procedural control with the whole litigation. Well, we have various classes or types of application, but there's a case which we call the Boston's Interim Urban City Council, which I put in the chat for you. And in this particular case, Lord, we'll put in the chat for you. Oh, okay, someone came back. Trying to show. Yeah, so in the Bosens against Altrincham Urban City Council, the Chief Justice Lord Alverstone made a statement which is relevant in terms of understanding whether an application, and for that matter, the outcome of it will give rise to a final or interlocutory order or judgment, as the case may be. So this is what he said. Does the judgment or order as made finally dispose of the rights of the parties? If it does, then I think it ought to be treated as final order. But if it does not, it is then, in my opinion, an interlocutory order. Now, when it comes to applications, there's that confusion as to whether applications and orders or rulings which are made are necessarily interlocutory or they are final. And that is why Alverstone said that, well, it's not so much about the nature of the application which is made, but it's about the outcome, the effect of the application. If the effect of the ruling or the order made when the application is made, for example, is going to dispose of the rights of the parties, then it's not just an interlocutory, if you like, order, interlocutory application, as it were, but it will be treated as a final order or final judgment. On the other hand, if it is not going to dispose of the right of the parties, and we still need to go through the trial process to be able to do that, then that is interlocutory order. And again, in such Ojumase Nyame against Kese alias Kunto, we were also reminded about whether a ruling or order which has been made can give rise to Estoppel. And that is why we are trying to look at the classification. Because as you know, we have the res judicata. If someone has, for example, brought interlocutory application for a default judgment, can it give rise to Estoppel? And that is why the classification is important. So look at the in re such a Dumase against Nyame and Kese alias Kunto. I think the case we've mentioned it before, so you have it. And Aqua JS, yes, he then was will make the point, which I could just listen, you don't need to. The plea of res judicata can be invoked in respect of any final judgment delivered on the merits by a judicial tribunal of competent jurisdiction. Such a judgment is conclusive as to the rights of the parties and their privies, and as to them constitute a bar to subsequent action involving the same claim, demand, or cause of action. And then he stated further that the plea of res judicata really encompasses three types of estoppel: cause of action estoppel, issue estoppel in the strict sense, and then issue estoppel in the wider sense. In summary, cause of action estoppel should properly be confined to cases where the cause of action and the parties or their privies are the same in both current and previous proceedings. In contrast, issue estoppel arises where such defense is not available because the cause of action are not the same in both proceedings. Instead, it operates where issues, whether factual or legal, have either already been determined in previous proceedings between the parties. So that is what they call like the issue estoppel in strict sense, like a particular issue has been resolved already, although the cause of action in the instant case is not necessarily the same as the cause of action in the previous case, but there is an aspect of the matter in the present cause of action which has been resolved in a previous case, and that will be like the issue estoppel in the strict sense. And then, or where issues should have been litigated in previous proceedings, but owing to negligence, inadvertence, or even accident, they were not brought before the court, then issued estoppel in the wider sense, otherwise known as the principle in Henderson and Henderson. So, if there was a case between those same parties and a particular issue could have been dealt with, but it was not brought up to be dealt with, the issue estoppel in wider sense will serve as a bar to an attempt to bring up that issue in a fresh litigation when that issue had an opportunity to have been dealt with in a previous suit between the same parties or their privies, as the case may be. So against the background of these principles in terms of whether it's a final judgment or final order, and for that matter, interlocutory application leading to final order, or just not leading to final order, how they affect Estoppel, res judicata. We can broadly put applications into two categories. So on the one hand, we have the interlocutory application. So interlocutory application regulates the progress of the suit or the litigation, as it were, without determining the final rights. But of course, as I said, based upon Lord Chief Justice Lord Aveston's position, which in research Odumasi also, in so many other Supreme Court cases seem to have endorse or buy into. There's not so much about the nature of the application, which matters, but it's about the effects or the nature of the order made at the end of the application, which is important. So therefore, it's not whether it was just an interlocutory application. For that matter, we say the interlocutory applications will not determine final rights. In some cases, it may be interlocutory application, but the decision or the ruling may have the effect of determining final rights. And for that matter, it can give rise to Estoppel res judicata. So example of interlocutory applications include interlocutory injunction or interim injunction, stay of execution, or you bring application for somebody to be ordered to make security for cause, amendment, discovery, striking out. All these are applications which are interlocutory in the sense that they don't determine the final right. So, for example, if you have interlocutory injunction will subsist until the time the court prescribed or until the case has finally been concluded. If you have self-execution is temporary, either pending completion of instrumental payment or pending determination of an appeal, or maybe if a judicial review or some others, as the case may be. So it has like a temporal duration. It's not supposed to remain in force, as it were, for good. Again, security for cause. If you bring an application for security for cause, particularly so, where you have like a plaintiff who does not reside in the jurisdiction or does not have any significant assets in the jurisdiction or something like that, you would like the court to let him make undertaking that if he should lose the case, he has made necessary arrangement for the cost which will be awarded against him to be realized by the defendant, as it were. Then we also have amendment. If you bring application for amendment, as you know, it's just to amend either a pleading or any document in the existing proceeding. An amendment per se does not bring about finality. And discovery, we'll be discussing discovery as part of a pre-trial today. You need to know certain documents or exhibits which are in possession of your opponent relevant to the pending suit. Those per se, if the court ordered them to allow the discovery to take place, it doesn't mean that it has determined who has won or who has not won, or whose right is upheld or whose right is not upheld. Again, striking out. Of course, with respect to striking out, if you look at something like Order 11, Rule 18, A, for example, if you are successful and then the plaintiff's cause of action is strike out for not disclosing the reasonable cause of action, or the defense, in a sense, it may pave way for some finality to be brought to the controversy, as the case may be, unless the affected party comes back to court later on. Now, apart from interlocutory application, we also have substantive applications. Substantive applications, they are filed as motions, all right, but they may effectively determine rights of the parties. Let's give example. Summary judgment, Order 14. Order 14 is not just an interlocutory application. It's in a sense a substantive application in the sense that it can actually determine the rights of the parties. And then a dismissal for want of prosecution, where you bring an application that someone has not prosecuted the case that he brought before the court. And for that matter, the court should dismiss it for want of prosecution. That could bring about finality. And again, jurisdictional objection. If you bring an application to object to the jurisdiction of the court or invocation of the jurisdiction of the courts, that is not just an interlocutory application because it has the capacity to bring about the end of the whole controversy, as it were. So the classification that we have done is important because depending upon the type of application you are dealing with, whether it is just interlocutory in the true sense of interlocutory application, the evidentiary threshold which you must meet is different, as opposed to if it's really like a substantive application. So let's take summary judgment, for example. If you want a summary judgment, the affidavit and then the supporting exhibit and so on required of you is certainly more than if you just have an application for amendment of, let's say, a pleading, as it were. Now, how do we make an application? We have seen already, and this is one of the first things we discussed, so I'm very comfortable with my students that you know these things already. I'm just recapping what we have done already, just to satisfy all righteousness, as it were. So, if you look at Order 19, Rule 1, we are told that every application should be made by what? By motion. So every application should be made by motion, and the motion should be supported by affidavit. That is a default rule, and we have discussed that. So what does the motion state? The motion paper is supposed to state the relief sought. What exactly are you looking from the court? What prayer? And then it should also state the legal basis. The legal basis for the prayer you are looking for, and the rules grounding the application. Although with respect to the rules grounding the application, as whether if you bring, for example, application for summary judgment, whether you should write Order 14 on the motion paper or you shouldn't write it. There are two schools of thought, but the one school of thought I think seem to have been championed by the recent Supreme Court judges, and so we say that that is the correct position or the dominant position now. Now, if you look at the case of Asamoah and Mafo, we've also mentioned that already, 2011 2 SGLR 832, we've mentioned that already. The Supreme Court made the point that, yes, ideally, if you have an application, a motion, it is good if the rule under which you are bringing the application is stated. However, if it is not stated, it is not fatal. So Aninyabua JS, as he then was, made the point clear in Asamoah and Mafo that, yes, it's not compulsory for a party to state the rule under which he proceeds. But if you actually stated it, that would also help the court and make matters pretty straightforward. And that was why in Boatin against New Patriotic Party, 2010-2012 2 Ghana Law Report 115 is a court of appeal decision. In holding 1 of the report, if you read it, Appel J, as it then was stated, where an applicant failed to disclose on their motion paper the rule or procedure under which an application was being made, the court should ascertain which of its powers was being invoked, and therefore which procedure to apply. The most practical manner to determine the properly applicable practice will be to examine the specific words used in formulating the grounds for the application. Good. So the takeaway from the Supreme Court decision in Asamoah Mafo and then the Court of Appeal decision in Boatin against New Patriotic Party is that it is a good practice to state the rule on basis of which the motion is being brought to the court. However, the failure to state it is not fatal to the motion. So therefore, if you become a lawyer, you don't just go and raise a preliminary objection and tell the court that because the applicant has not stated the rule on basis of which the application is brought, the application should be dismissed eliminate or should be struck out as being incompetent. No. The authorities to the effect that that is not fatal. But then there is something that is said in Boatin and New Patriotic Party in the holding 1, which I just read for you. And one thing we need to learn from that is that he said that where the motion paper has not stated the rule, then what the court should do is to examine the specific words used in formulating the grounds for the application on the motion paper. And for that matter, when you are crafting the prayer, it's important to craft it well. Should it happen that you fail to state the rule, the prayer and the basis of it will enable the court to know the relevant rule of procedure which is being invoked, despite the fact that you fail to expressly mention it on the face of the motion paper. So let us keep that in mind. And of course, application or the motion must specify the grounds on which it is based. And that is why that is Badebe in the case Ni. Let me show you that case. That's that Badebe in the case Ni Ba and Harriet Morrison, Ni Ba and another against registered trustee Victory and others. It's a 2015 decision of the Supreme Court. That the mere reference, Badebe speaking, the mere reference in what I consider to be an argumentative deposition to certain words in the said paragraph 19 without more will suffice for the purpose of the form and substance of the application. In any event, in making the application, the applicant is required to specify the said grounds in the body of the motion paper and not cause the respondent thereto and indeed the court to search for the grounds from the affidavit in support of the application. So what His Lordship is reminding us that it is better to state the grounds of the prayer which you are seeking on the motion paper, not the affidavit. The affidavit is supposed to speak to the factual narratives, but the ground of the prayer you are looking for will certainly be something of legal character, and that should be stated on the motion paper. And again, it's not an argument. You are not building an argument there, no. Another point we should also note is that all motions in pending proceedings must be on notice. All motions in pending application must be on notice. We've read Order 19 already extensively, and you're all very familiar with that. So as a rule, as a default rule, every application, every motion should be on notice. And we have explained why that is the case. So therefore, if we look at the case of, as for the case I've told you, every principle, every point, you can get more than 10 cases. So it's not so much about the number of cases, which is important. I just know a handful, and that will suffice, but understand the principle well. So in the Republic against the High Court, Kufuordia, ex parte Augustus Osai, the court made the point, and I quote, Order 19, Rule 1(3) of CR 47 requires that all motions in pending proceedings shall be made with notice to the parties affected, except where the rule otherwise provide. It is for this reason that counsel submit that application under Order 25, Rule 2 shall have been on notice to the defendant. From the record, when the orders of 15 December 2008 were made, the rate of summons had not been served on the defendant for him even to enter appearance. Therefore, there was no way he could be given a hearing application for the order for the preservation of the vehicle. Consequently, the court under Sub-Rule 1(4) should have either dismissed that part of the motion, which the rules will not permit that should be made ex parte, or adjourn the hearing, in order that the notice may be given upon such terms as is considered just. By granting the application, the court acted on travaris, and orders made are therefore null and void. So the takeaway from ex parte Augustus Osai is that, consistent with Order 19, Rule 1(3), all applications should be on notice. And I've told you before that even where the rule says that it can be ex parte, and if putting it on notice is not going to hurt you, I would rather recommend that you go on notice, because that ensures that the natural justice principle is properly upheld. Audio terram partem. You hear both sides of the matter. You give the other side to also present their side. So let's keep that in mind. Good. So the motion should be served, as we have indicated. We look at the Rule 3, and there used to be this thinking that there should be 3 clear days, and if the 3 clear days is not actually met, then automatically nothing can be done. No. If there's a short service, let's suppose that the application or the motion was filed on Monday. So 3 clear days will be Tuesday, Wednesday, Thursday. Now, if, for example, Wednesday, the return date is Wednesday, but then the person was served on Monday, the 3 clear days has not been met. Now, all that will happen is that on that return date, the court will have to adjourn the application unless the affected party waives his right to be served the 3 credits. And of course, this is a kind of non-compliance, which is not a nullity. It is irregular, and that is why the court will adjourn to enable the other party time as prescribed by the rules. But we also have ex parte application, as we've discussed already in class, and in appropriate cases, if you look at the 19 Rule 3, there can be a waiver of service, because ex parte application simply means that you are bringing the application without notice to the other affected party, and that's why we say ex parte. You come without notice or bringing it to the attention of the other party. And by its nature, service is waived because it's ex parte. You don't need to serve the other party. Well, if you serve the other party, it will no longer be ex parte. It will be a motion or not, or notice. So let's keep that in mind. But we should remember, as we said in the classroom a couple of weeks ago, that ex parte applications are exceptional. They are the exception rather than the norm. The default position is motion or notice. Now, ex parte applications are justified where we have urgency. We have urgency. And then notice will defeat purpose. The nature of the application is said that if it is on notice to the affected party, it will be counterproductive. Then there'll be no point even bringing the application. Or where interim preservation is necessary. Why interim preservation is what is necessary. And for example, those days we have this what you call the absconding absconding order or absconding arrest, where you have the defendant who is suspected to be trying to put himself beyond the reach of the jurisdiction, and then you get the notice that the person is within the jurisdiction. You may want to get an order for him to be, absconding warrant for him to be, as it were, arrested and brought before court, and then for him to show cause why he should not be restricted, as to, or the court may ask him to execute some bail or bond or security to ensure that he will not run away and he can be rich for the proceedings to go on. So that type of application, for example, you cannot bring it on notice to the affected party, because if he gets to know it, if he's actually intend to abscond, to run away, will actually run away. So those are some of the things. Or sometimes when it comes to intellectual property, litigation, where we have maybe some alleged infringement or some other things going on, you may need to surprise the alleged offending party by storming the person premises in order to go and take the exhibits or the products which constitute the violation of the relevant intellectual property rights. So that will have to be done on a ex parte basis without notice to the affected party. And in view of the obvious injustice associated with ex parte applications, the court has warned a number of times that ex parte application should be given sparingly. So therefore, if you look at the case of Republic against the High Court Accra, ex parte Salom, senior coca interested party, the Supreme Court cautioned that ex parte relief must be granted sparingly and with full disclosure. So if you are going ex parte, you have to make sure that you don't withhold any vital or relevant information from the court. Now, if you did that, subsequently, the affected party, when he come to know of the order, certainly will get to know of the order, we're going to be served on him. He can conduct a search or take some other steps and bring an application to tell the court that you obtain the ex parte order irregularly, or sometimes even if it was fraudulent. That could bring about a whole lot of things. So I want us to look at the case of Barclays Bank of Ghana Limited against the Ghana Cable. And there, the point was made by Aqua GSC, who later became the CJ, that quote, for it is not permissible. It is not permissible. It is not permissible, and indeed, it is a travesty of justice for a court to make an ex parte order remain in force pending the final determination of the suit, or pending the application on notice to the other side. Now, orders made ex parte are anomalies in our system of justice, which generally demands service or notice of the proposed proceedings on the opposite party. Nonetheless, the power of the court to intervene immediately without notice in proper cases is essential to the administration of justice. But this power must be used with great caution and only in circumstances in which it is really necessary to act immediately. Such circumstances do undoubtedly tend to occur more frequently in family disputes, particularly when a marriage is breaking up in a state of high emotional tension. But even in such cases, the court should only act ex parte in an emergency when the interest of justice or the protection of the applicant or a child clearly demands immediate intervention by the court. Such cases should be extremely rare, since any urgent application can be heard inter partes on 2 days' notice to the other side. So, the learning from this judicial dicta is that ex parte application should not be granted lightly. It should only be granted by the court in deserving cases. And deserving cases are those cases where full disclosure of the relevant information have been made by the applicant. And the circumstances of what is being sought is said that if it is not granted ex parte, it's going to create a significant harm or injustice, as the case may be. Another point we need to note is that applications should be accompanied by affidavit, as we have you've noted. But what is an affidavit? We discussed Order 20. We discussed Order 20 extensively, and even practice how to write an affidavit. So affidavit is simply a sworn statement, a sworn written evidence. Evidence which has been reduced into writing, and of course, since an evidence is made on oath. And the courts have reminded us time and again, including the case of Republic against High Court, Kumasi, ex parte Atumfuwa, 1999-2000, 2 GLI 599, that an affidavit is evidence, it's not argument. And this is very important. Practice has emerged now where some practitioners, instead of concentrating on the true role of affidavit, they will also use it to canvass argument. But as part of 25 reminds us that an affidavit is evidence, is not supposed to be what? Argument. And affidavits, as you notice, replace oral testimony in motion proceedings. If you're having normal trial, witnesses will enter the box. They are sworn. They give the evidence in chief. They are cross-examined and maybe re-examined. But when it comes to affidavit or motion proceedings or applications, most of the times we don't use oral testimony. We just use affidavit evidence. And in the case of Poku and Poku, 2008, 2009, 1 GLI 501, the Supreme Court reminded us that all affidavits must be drafted with utmost care. All affidavits should be drafted with utmost care, and the case for each side being set out with clarity and precision, with nothing left to chance. The reason being that the matter stands to be judged along the issues emerging from the affidavits filed by the parties. And this was the Chief Justice Wood speaking in Poku and Poku, that we have to put some effort and thought into crafting or the writing of affidavit. Because when it comes to applications or motions, they are determined on the strength of the affidavit evidence. And that is why we then need to be skeletal if we have the true facts, the true information there, including the supporting exhibit, documentary exhibit, as the case may be. It should properly be set out in the affidavit. And similarly, the case of Republic against High Court, Financial Division Accra, as parte Xenon investment, the Justice Edinia Boa, as he then was, gave a very important exposition by quoting the Atkins Encyclopedia of Forms, and this is how he put it as far as affidavit is concerned. Quote, the nature of an affidavit is well captured in the authoritative works in Atkins Encyclopedia of Courts Forms in Civil Proceedings as follows, quote. So he's quoting the Atkins. An affidavit is a written statement of evidence sworn by the person making it, who is called the deponent, before a person authorized to take affidavits, and where admissible, receivable in legal proceedings as evidence either in support of an application or in answer or reply. So the authors or the editors of the Atkins Encyclopedia of Court Forms, I think they put it quite poignantly as my Lord quoted it. An affidavit is a written statement of evidence sworn by the person making it, who is called the deponent, before a person authorized to take affidavits, and where admissible, receivable in legal proceedings as evidence either in support of an application or in answer or reply. Then he added, affidavits are commonly used in interlocutory application to provide factual basis in support or answer to the positions. Yeah, so that is basically the nature and character of affidavit. It's a sworn written statement, it's an evidence, it's an oath. And as we have indicated, in terms of Order 19, every application, whether ex parte or notice, should be accompanied by affidavit. And affidavit is supposed to play the function of setting out the factual basis supporting the prayer, and then the legal grounds for the prayer you have on the motion paper. The factual basis will have to be set out in the affidavit. And let me remind you, maybe somebody will be wondering, then what about statutory declaration? Good. We have the Statutory Declaration Act, and statutory declaration is similar to affidavit, but is different. They are not the same. Statutory declaration is also a sworn statement by the declarant, making a solemn statement that certain things he is saying are true to the best of his knowledge. Now, statutory declaration is not required for proceedings in court. Like, it's not required, generally or routinely for proceedings in court. But whenever you need to make a solemn confirmation or a solemn statement or declaration concerning certain facts or matters outside pending court proceeding, you do so by using statutory declaration. Sometimes in the course of trial, a statutory declaration, maybe which was probably made by someone concerning either a land or a certain gift or whatever, may be tendered. But then when it is tendered, it's just a certain supporting documentary evidence, but it's not being used in place of affidavit, as it were. So as I said, affidavit applies properly to pending court proceedings. Statutory declaration applies to non-court proceedings in which a person is required to make a sworn statement. But the maker of a statutory declaration is called a declarant. And then the maker of an affidavit is called a deponent. So we don't use a deponent in statutory declaration. We use deponent in affidavit. And you don't use declarant in affidavit. You use that in statutory what? Declaration. So don't let us confuse the two. Affidavit must be sworn, as we have seen. And in this regard, Order 20 Rule 2, and also the Oaths Act, we have a whole legislation on oaths. So look at the Oaths Act 1972, NRC Decree 6, Section 9, subsection 1, which provides that affidavit must be sworn before a judge, magistrate, registrar, commissioner for oaths, or officer authorized by law. Now, Order 20, Rule 11 is quite explicit that affidavit should not be sworn before the lawyer of the party. So if your client needs to do affidavit and you commission the affidavit, you let him swear and then you sign as if you are the one before whom the affidavit is commissioned. Now that is forbidden by the law. You are not supposed to do that. Certainly, that will not be right. And why won't it be right? Because of the obvious conflict of interest. Because you and your client, you essentially have the same position of the matter. So why should you be allowed to be the one officiating the taking of his evidence? Now, we've talked about the form and structure of affidavit before. Order 20 before we read it in class. The form that the affidavit should be. Of course, the affidavit must be in the first person. That is I. And then it should be divided in paragraphs. I'll show you a sample when you finish. I'll show you a sample of a motion and affidavit on the screen. it should be divided into paragraphs. Then it should also state the full address of the deponent and state the place where the swearing took place. That is important because if there is doubt as to whether it was properly sworn or not, we need to actually establish that. So if you know the place where it was sworn, then that is good. Please, just 1 minute. In my camera, I can see that my little daughter wants to go out of the gate. Let me, otherwise, she may run down by a car. Yes. Yeah, thank you. Yeah, so I said part of the form should be the place where the swearing took place, so that if there is any doubt in future, we can trace and establish it. Of course, the date should also be stated. And when you look at the sample, you notice that all these things are there. It's important when you are drafting affidavit to let one factual deposition be given one paragraph. One factual deposition, one paragraph. And when you make the factual deposition and there's a supporting document, immediately after making the deposition, they indicate that exhibit. Some lawyers will say vide, or some will just say C exhibit. And then the exhibit, you label the document, and the labeling, if it's a trial, the plaintiff will use the alphabets. So maybe exhibit A, exhibit B, exhibit C. If it's the defendant will use numbers, exhibit 1, exhibit 2, exhibit 3. But when it comes to motion proceedings, affidavits, we don't usually go by that. And we rather use the initials of the deponent to label the exhibit, so that if the deponent is an associate exhibit EOD, then if there's another next exhibit, to be exhibit EOD1, exhibit EOD2, exhibit EOD3, that order. Now, in terms of the contents of the affidavit, we've talked about the 20 already. That the affidavit must contain facts within the deponent's personal knowledge. Within the deponent's personal knowledge, or if what he knows is not from him, but based upon information or advice which will be given to him by his lawyer or whatever source, there should be statement of the information or the belief with the source disclosed. So how did we come to know about it? We must disclose the source so that we know. Particularly so if it's not from your own personal knowledge. Affidavit must not contain arguments. It must not contain legal submissions. It must not contain speculations or irrelevant narrative. Affidavit should talk about things which have actually happened or are likely to happen based upon reasonable basis and not just any speculation. And affidavits are evidence. They are not briefs, so they are not illegal submissions. So lawyers who try to put submissions in affidavit is absolutely wrong, because that is not the finding of affidavit. Affidavit is evidence. Under 20 Rule 14, as we read not too long ago, requires that there should be certificate of exhibits. Sometimes some practitioners forget to ensure that there is what we call the certificate of exhibit. If in the affidavit you have alluded to exhibit, like documentary exhibits, now when you finish, you must list all the exhibits which you alluded to, and then you ensure that it is certified. And the certification simply means that the person before whom the affidavit is sworn is certifying that he has actually seen those documents which we have referred to in the affidavit as having been exhibited or made part of the affidavit, so that it is one complete document. If you read Mr. Tete's work, particularly if you look at the page 789, he will remind us that when it comes to affidavit and exhibit, relevant documentary evidence that buttresses the position of the deponent must be exhibited, however bulky it may be. It doesn't matter that you are going to have bulky documents, because if that is what actually supports the position you are making, and the court is going to make up its mind based upon affidavit evidence, then it will be better to exhibit it rather than to say that, oh, this document is bulky, so I'm going to keep it away. For all you know, that may give a certain meaning and certain effect to the depositions that you have, and that will enable you to have the court grant you what you are looking for. So let us keep that in mind. We also have affidavit in opposition, opposing affidavits. And if anytime there's an application or motion or notice, two set of affidavits or two category of affidavits are to be seen. The applicant will have the affidavit in support, either by himself or by some other people who are supporting the application. And then we have the affidavit in opposition. Affidavit in opposition. And the affidavit in opposition is deposed by the opponent, that is the other party against whom the application is blocked. He is called the respondent. The cases of assuming and others against Diversity Implementation Committee has been referred to you in your manual. Please read it, which requires that if you are responding to an application, you may file an affidavit in opposition. Otherwise, uncontroverted affidavit evidence may be accepted as true unless inherently incredible. So if the applicant has filed affidavit in support and you are the respondent, you don't file affidavit in opposition, then the general rule is that you are not challenging the deposition in the affidavit in support. And for that reason, unless there is some inherent, incredible or unbelievable, deposition therein, otherwise the court will give credence to whatever is contained in affidavit in support, because you have not put up a rival version. So the court does not need to evaluate as to which one to believe or not to believe, as the case may be. So let us keep that in mind. So Mr. Tete, for example, if you look at his work, page 430, he will make the point that the court may order cross-examination of the deponent to an affidavit, failing which the affidavit must be rejected. So he was referring to the fact that where there is uncontroverted affidavit evidence and there are certain depositions contained in it, which, for example, by their nature, are inherently incredible or they sound strange, the court has the power to allow the affected party to cross-examine the deponents of the affidavit if the court considers it necessary, as it were. So look at the case of Republic against District Court, Grade 1, Kolegonu, parte, Ampuma. And again, the case of Republic against High Court, Accra, parte, Concord Media. Let me show you. Justice Enene Boa, as he then was, who became Chief Justice later on, made the point that in contentious matters where the facts are in issue, the superintending court may allow an application for deponents to the affidavit to be cross-examined. It's not automatic that you'll be allowed to cross-examine anytime we have affidavit. But in parte, Concord Media Limited, Alfred Obame, Ghana Post and Harbors Authority Limited, interested parties, Adenia Boa GS, as he then was making the point that where you have a very serious, complicated, facts, and an application is brought seeking to cross-examine a deponent to an affidavit, that may be permitted. That may be permitted. But again, all the time, the request should be made. It's not as of right. It's a discretion. The court has a discretion to allow you to cross-examine a deponent of affidavit or not to do that. Otherwise, if the court was actually to allow cross-examination in all manner of application, you can imagine the chaos which we have. Because as we notice, as far as litigation is concerned, almost every now and again, there are applications. So if in every application, an applicant or respondent says that I'd like to cross-examine the deponent of the affidavit, the courts will be inundated with too many proceedings, and may even affect the time to deal with the substantive matter before the court itself. And that is why the courts have said that when there is an application before the court, it is up to the court or the judge to determine how to conduct its proceedings. And that point has been made time without number, including the well-known case of Republic against Court of Appeal, as parte Eastern Alloy Company Limited, 2007-2008 Supreme Court of Ghana Law Report, where Justice Atukuba made the point that, quote, the second ground is based on the barest technicality, i.e., the motion was dismissed on the merits, even though it had not been moved by the applicant. I'm quoting Atukuba GSC. It is difficult to see how this plaint can be outside the clutches of the principle of waiver either. Certainly, the right to move a motion is the same as the right of the applicant to be heard on the motion. And if the right to be heard is waived, it must follow that the right to move is also waived. It is established practice, however, that in such a situation, the motion is normally struck out for want of prosecution. But there is no rule of law that a court cannot, in such circumstances, elect to hear and decide the motion on its merits, unless it is moved by the applicant, who chose to be absent on the hearing day of the motion. Every judge, subject to particular rules, has the right to control the proceedings of his court. Therefore, how a motion should be dealt with is within the judge's discretion, whether a party be present or absent. Then he cited the case of Petrograph Limited against Lee Smith Photo Mechanics. Yeah, so the court was trying to tell us that when it comes to how to deal with the motions, and which in my view also include whether leave will be granted for cross-examination to be done, for a deponent of an affidavit to be cross-examined by the opponent. It is a matter within the discretion of the court. So you need to, of course, you need to ask yourself, why do you think that the deponent should be cross-examined? You need to set up the convincing case, and then the court will look at it. Now, let's say a few words about defective affidavits. Order 20 Rule 7, we've discussed or we've mentioned that before in court, that an affidavit may, with leave of the court, be filed or used in evidence, notwithstanding any irregularity in its form. We have already seen the form which an affidavit should follow in terms of Order 20 Rule 4. Now, where the affidavit you have does not, for example, meet the strict requirements of Order 20 Rule 4 in terms of like the formalities, technically, it is a defective affidavit. However, it does not mean that it is completely fatal. No. The court has a discretion to permit the use of defective affidavit which does not strictly conform to all the known formalities of affidavit. So let us keep that in mind. And if you look at the case of Republic against Eduedu, as parte Amidu, 2001-2002, 1 Ghana Law Report 272, the court exercised discretion to cure irregularity. So it's not every defect which is fatal. So let's keep that in mind. But of course, there are some defects which are not defects going to formality. Some defects go to the substance. So where it is a substantive defect, for example, affecting oath, that may invalidate the affidavit. Affidavit must be sworn. The requirement that it should be sworn is not a formality. It is that which actually give efficacy and validity to the affidavit. So where the affidavit is not sworn, it's not an affidavit. It will have to be, because the affidavit by definition is a sworn word. It's a sworn written evidence. So if it is not sworn, it does not meet the threshold of affidavit. So that is not the kind of irregularity that Order 20 Rule 9 is talking about. Because if we look at Order 20 Rule 9, the textual position is quite clear, and I read it. An affidavit may, with leave of the court, be filed or used in evidence, notwithstanding any irregularity in this form. Now, in terms of form, if you go to Order 4, we have like the form of the affidavit, as it were. And if the affidavit does not strictly, for example, meet that, it can be permitted to be used as the case may be. We also have applications which do not require affidavit. So if you look at the Order 19, Order 19 Rule 4, for example, Order 19 Rule 4, which says that every application shall be supported by affidavit deposed to by the applicant or some person duly authorized by the applicant and stating the facts on which the applicant relies, unless any of these rules provides that an affidavit shall not be used, or unless the application is grounded entirely on matters of law or procedure, which shall be stated in the motion paper. So, where the application you are bringing before the court, the prayer you're looking from the court, you don't need any facts to serve as the background to enable the court to decide whether to grant it or not. And it's grounded purely on points of law. You don't need affidavit. You don't need affidavit. Again, if you bring application for directions, if you look at Order 32, okay? If you look at Order 32, for example, Order 32 of 747 talks about application for direction. And if you bring application for direction, you need only the application paper. You don't need affidavit. You don't need affidavit. So if you look at Order 32 on application for directions, no affidavit is what is required, as the case may be. Again, where the application you are bringing is such that the relevant facts are not in dispute, affidavit may be unnecessary. Where there is no reasonable no dispute to the facts, affidavit may be unnecessary. And that is why, in the case of Edward Mensah Dapo against Tay Akron, 2016, 95 JMG, that's the Ghana Monthly Judgment, 71. If you look at page 81 to 82, the Court of Appeal, speaking through Justice Akwe, made the point, and I quote, also from the provision of Order 19 Rule 4 of CI 47, the exceptions to the rule that every application shall be supported by affidavit are when the rule exempts affidavit evidence and when the applications are granted entirely on law or procedure which shall be vested on the motion paper. Now let me tell you this. You know, I'll be telling you in the classroom that the cases are good, but they are not important as understanding the principles. Now, if you look at the case that I just cited, what the case has stated is just to repeat Order 1904. So if you understood Order 1904 and you don't even know the case of Edward Mensah Dapo against Terry Akron, you don't lose anything because that is the law. We are going to look at how the motion is drafted. We've done it before. I'll just show you an example and then we move on. So maybe just in terms of like the guidance, just to be sure, I think I have some old motion. I will just show quickly to you and then we move on to discuss the pre-trial proceedings and other things. Good. So if you are going to draft a motion, a good motion, or a compliant motion, so to speak, must include the title of the suit. The title of the suit, of course, you have like the forum, the venue, the court, in the High Court or in the Circuit Court, as it were. Then the place, Accra or Kumasi or wherever, you indicate it. And then you have like the title, we have the parties, the plaintiffs, the defendants, and so on. Then you have the, of course, the motion, paper itself, you have like a title. That like motion or notice, isn't it? Motion or notice or ex parte motion. And it's better to let that capture the substance of what you are looking for. Motion or notice for an order for amendment, or motion ex parte application for certificate service. So if you want, you look at like the heading, it gives us some quick idea of what exactly the motion paper is going to seek. Of course, the rules, grounding the application. If you know it, it's better to state it. If you know, it's better to state it. Sometimes you see lawyers writing inherent jurisdiction of the court. Inherent jurisdiction of the court will become necessary where the particular thing that you are looking for is not founded upon any particular rule of law. Because if there's a known rule of law, it's not just a matter of the inherent jurisdiction of the court. You have to come under that particular rule. Of course, the supporting affidavit, the exhibits, and also address for service. An affidavit, as we have said, must contain numbered paragraphs, state material facts, avoid argument, and then attach the certified exhibit. So let's look at the example. So for example, maybe example of this, reduce that so that. And so we have like the, like the court, in the High Court of that says Commercial Division, let's say Kumasi, Ashanti, 2021. And then you have like usually like the suit number. The suit number comes the right side. And then we have like the title, like the parties. This one is what they call the interpleader proceeding. We'll discuss interpleader later when we discuss execution of judgments. So in the matter of Export Finance Company Limited, that's the plaintiff against Fumadu Ghana Limited, defendant. In the matter of notice of claim, interpleader by Enrico Maranecci, a claimant applicant. Motion or notice for interlocutory injunction order. And interlocutory injunction, I think it should be like this. the order. Usually that the rule should be under the the motion or notice for the local injunction, then under order 25 rule 1, or assuming it was like a motion or notice for amendment, that would be like a order what? Order 16, CI 47. And a motion paper. Motion or notice by Dr. So and so of the Power Law Association and so and so. Lawyers for and on behalf of the claimant applicant hearing, praying for another of the Honorable Court. 1. Restraining so and so at a particular place pending final determination of the interpleader summons, suit number so and so pending before the High Court. And also restraining the Deputy Sheriff, the High Court Commercial Division, from authorizing the sale by auction of the disputed property situated at Ejoso, pending the final determination of the interpleader summons pending before the High Court Commercial Division, Kumasi. Yeah, so that's like the motion paper. And then usually you have like the omnibus prayer. The omnibus prayer is like the and for such further orders. And this simple phrase, sometimes it can make a whole lot of difference in the courtroom. Because and for such further orders, it opens up the window that, yes, when the court deals with the affidavit and all the things that you have said over there, if there is anything which the court think needs to be done for you based upon the information that you put before the court should do it. And that is why usually, in practice, they will add, and for such further orders, as the court may deem fit. And then you have like the court to be moved on, the date of the place, the chambers where it was done, the name of the lawyer, then the license number of the lawyer. The case of Tariwaja, which says that you must actually indicate your solicitor's numbers, and the chamber's registration number is also indicated. Then it's addressed to the registrar. The registrar, and then copy for service on the other party. Or sometimes if the lawyer is known, this lawyer, as the case may be. But for a process like this injunction, it's better to serve it on the party. You don't serve it on the lawyer. Because if the party is not served and is even doing the very thing you are seeking the court to restrain him, it may be difficult for you to cite him for contempt of court, because he can say that, well, my lawyer never showed this thing to me. And if the lawyer also so to affidavit and say that the court cannot actually hold the party responsible for doing that which the injunction is supposed to restrain him from, so you'll not be successful in any future contempt of court application against him. But then if you serve it on him directly, then it will be easier if he continued to do the very thing that the application is seeking to restrain him from doing. Then we have like the affidavit. The affidavit too should have the same, like, the title, the court, the name of the court, the suit number, the title, the parties, as you can see. And then affidavit in support. Sometimes some practitioner will say affidavit in support, let's say they can add. So here the deponent is Enrico Maranacci. So some people, for example, do that affidavit in support by Enrico Maranacci. So that is one. Then you also have some practitioners who may even go to the extent of using this one. They would actually take the motion, this thing, okay? They will take this one, and then they will come here. Affidavit in support of affidavit in support of a motion or notice for interlocutory injunction. Some may also do that. I mean, they are just question of style. They are all correct. If you just did affidavit in support simpliciter, or if you did affidavit in support and then you add like the particular motion to it, affidavit in support of motion or notice for interlocutory injunction, that is fine. Or if you just did affidavit in support and then you added the name of the deponent. Now, adding the name of the deponent may be necessary where you have more than, where you have more than one like affidavit supporting the application. It's possible to have multiple affidavit supporting one application or multiple affidavit in opposition in relation to a particular application. So where that is the case, then it will be quite prudent for you to indicate the name of the deponent as part of the heading of the affidavit. So the affidavit in support by Kokumensa, affidavit in support by Emifa, affidavit in support by like just put your name there, Mami Saba, Madeline, Kyla, whatever, yes. So after that, we come to the body of the affidavit itself. So the deponent will have to be mentioned first. So usually it has to be like the first person. I, Enrico Marinetti. They will have to indicate the residential address of house number block SY7 Ahinsan Estate Kumasi in the Ashanti region of Ghana. Do make oath and say as follows. So here too, there are two styles, okay? This is one style. Another style will be, let's finish this style. Then when we finish, we will do the other style so that you decide which one you want to use. That I'm the claimant, applicant, and deponent herein. That the depositions I make, unless otherwise stated, are based on my personal knowledge, information, and belief. 3, that my late father, Enzo Marinetti, was the sole shareholder of Fumado Ghana Limited. 4, that Enzo Marinetti and one Baldwin Albert Alote were the directors of Fumado Ghana Limited as of 2002. 5, that Fumado Ghana Limited, I want you to pay attention. You notice that all the things we are talking about are essentially facts. That the Fumado Ghana Limited is the lessee of all that piece or parcel of land known and registered as Societal Achel Kromnia Juso. If you know where Anita Hotel is, I think that is where the property in question is. 6, that the sole shareholder, my father, Enzo Marinetti, died intestate on 21st April 2002. 7, that upon the death of Enzo Marinetti, I applied for letters for administration to administer his estate, and same were duly granted. And look at it, exhibited a markers, exhibit EM1. And I told you that you can usually use the initials of the deponent to label the exhibit. So the deponent here is Enzo Marinetti. So the first letter, E, Enzo, and then the other name, first letter M. So we are referring to the letter of administration, which he's alluded to now. He's saying that he's exhibited it, okay? So he exhibited the markers, exhibit EM1. It's a copy of the letter of administration. Some lawyers will also not do it this way. They'll do it like this. Look at this, boss. They'll do it like this. Instead of saying exhibited, they'll just simply say that vide. Vide is just a Latin. No, video means see. Okay, see. And that's why we have the word video. Video. So exhibit EM1 is a copy of the letter of administration. So that's another way of putting it. Okay. Then continue. That I have been advised by counsel, and I verily believe same to be true, that by operation of law, all Enzo Marinetti shares in Fumado Limited form part of his estate. So here, look at this deposition. The source of the information. Now he's trying to assert a certain legal inference. He's not making argument. He is a lay person. He's saying that based upon what he has said, his lawyer has told him that by law, if his father was the only shareholder in the company, then if the father has died, his lawyer has told him that by operation of law, his shares will become part of the father's estate. 9. That I subsequently caused a vesting assent to be prepared, vesting his estate, Enzo Marinetti's estate, including his shares in Fumado Ghana Limited in me. Then he's made reference to the vesting assent, exhibited a mark as EM2. It's a copy of the vesting assent. That my attention was drawn to some court documents that had been posted on the disputed premises, and the study of same revealed there were execution processes from the court seeking to attach assets of Fumado Ghana Limited on the grounds that the company had defaulted in payment of a loan it had contracted. 11. That I took steps and obtained copies of the court processes on the strength of which the said judgment had been obtained, giving rise to the execution. Then he refers to another document, exhibited and marked as exhibit EM3, 3A, 3B are copies of the rate of what? Sermons, statement of defense, and terms of settlement from the case that he has alluded to. 12. That per the rate of sermons, exhibit 3, the person who applied for the said loan purportedly fund on behalf of the company Fumado Ghana Limited in or on around 10th October 2003 claimed they were directors of the company. Exhibited and marked as EM4 is a copy of the loan application form. That a check at the Registrar General Department revealed that none of the said persons who had applied for the said loan, the subject matter of the execution, was indeed a director at the time they applied and were granted the said loan. He makes reference to another documentary support. Exhibited and marked as EM5 is a copy of the notification of change of directors or secretary or in their particulars. 14. That it is also evident per EM5 that at the time the said loan was contracted, Fumado Ghana Limited had no existing director, and this further cast serious doubt on the legitimacy of the said transaction. 15. That a casual glance at the so-called terms of settlement, the very foundation of the execution process, reveals that only one of the defendants by name, Edward Anoche, was the one who signed for behalf of the defendants. 16. That interestingly, the said Edward Anoche was the third defendant in the substantive suit and had, prior to signing the purported terms of settlement, applied and had his name struck out as a party in the said substantive suit. Then he makes reference to other supporting documents. Exhibited and marked exhibits EM6, 6A, 6B are copies of the application, the supporting affidavit, and court notes respectively. 17. That I have been advised by counsel, and I believe saying to be true, that exhibit 6, 6A, and 6A cumulatively cast serious doubt on the legitimacy of the purported terms of settlement, the very foundation of the execution process. 18. That it was patently clear from the available documents that there was an orchestrated design to deprive Fumado Ghana Limited of its assets through a very tainted execution process. 19. That as a sole shareholder, I deem it a duty to protect the assets of the company, so I caused my lawyers to file a notice of claim to challenge the tainted execution process. Exhibited and marked as EM7 is a copy of the notice of claim. Now later on, when we are discussing execution, if you have a property and then somebody, a supposed judgment creditor, is supposed to level execution against it, thinking that it belongs to a judgment debtor, but then you are not a judgment debtor, you have to file what you call like a notice of claim with respect to that particular property, in respect of which the attachment and fee will have been posted. So that is exactly Enrico Maranache did in this particular case, as we can see from the depositions. 21, that while both suits, 20, that on the advice of our lawyers, Formado Ghana Limited and I commence another suit in Accra, Commercial Division, to set aside the judgment on grounds of fraud. We've made the point before that if you are seeking to set aside a judgment on basis of fraud, obtained on basis of fraud, you need to do so by a fresh suit. You cannot just go before the court by application and expect the court to vacate a judgment because of a certain fraud. You have to issue fresh writs, set out the particulars of the particulars of the fraud, and then at the trial you bring evidence to actually prove the things that you are talking about. That while both suits are still pending before the court, my attention has been drawn to a series of advertisement of purported auction sale of assets of Formado Ghana Limited. Exhibited the mark as Exhibit EM8 is a copy of the notice of auction sale advertisement. 22, that I caused my lawyers to conduct a search at the registry of this court, and same confirmed that the interpleader summons contesting the purported tainted execution process is still pending before the Honorable Court. Exhibited and marked as EM8 is a copy of the search report. Now let's look at 23. That I have been advised by counsel and very believe same to be true, that it is contrary to law to go ahead with the conduct of any such sale during the pendency of both suits, challenging both the tainted execution process and the judgment respectively. That on receipt of the search report, I caused my lawyers to notify both the registrar of the court and Oceania, one Samson J. Ajate of Assessment, in a letter dated 12 March 2021, exhibited the mark as EM9. It's a copy of the said letter. As you will notice, this affidavit, which has so many supporting documentary exhibits. 26, that I was compelled to cause a press release to be published in the 18th March 2021 edition of Daily Graphic, cautioning prospective purchasers to disregard the said auction sale notice. Exhibited the mark as Exhibit 11 is a copy of the said press release. 27, that is very evident from all indications that the said judgment creditor is bent on going into execution of the tainted judgment at all costs, despite the dependency on the interpleader summons, unless restrained by the court. 28, that I have been advised by counsel, and I believe same to be true, that if any sale is allowed and third parties acquire any right in the process, it will lead to multiplicity of suits. That in the circumstances, I pray the Honorable Court to grant the instant application to maintain the status quo, pending the final determination of the interpleader summons. Wherefore, I swear to this affidavit in support. And then we have the place where the swearing took place, sworn at Kumasi. Then the date. The date will be the day of March 2021. The deponent, that is the signature of the person who is making the position. Then it has to be sworn before a commissioner for oath. So here, before me, commissioner for oath. The commissioner will sign here and put this stamp there. So that is how it is. And then we have the this is supposed to be a separate document because I did the copy paste. Good. Then we have the certificate of exhibit or identification. A certificate of identification. And then if you look at the law itself, or the 20/14, it talks about the certificates of the exhibit. So either certificate of identification or exhibits. We can see identification of exhibits. So here, so this will be like the commissioner for oath, the person before whom the affidavit will be commissioned. He would certify that he has seen the various documents being exhibited as alluded to in the affidavit. And so you provide like the map, like the list. As a EM1, what is it? Copy of the sale letter of administration. EM2, copy of the vesting assent, so on. You list everything, okay? And I want you to pay attention. That's why I've taken my time to show you example so that you can do it. Then after that, you have the dated at Kumasi, or if it's Accra or Tamale. This day of March 2021. And then the commissioner for oath. Commissioner for oath. Before the commissioner of oath, before me, he will sign here and put the signature there. So the commissioner of oath will sign twice. He will sign, put the stamp on the certificate of identification of exhibit, or simply put certificate of exhibits. And then he will have also commissioned the affidavit itself, put the signature and stamp there. Now, what is lacking here, but because I did just a copy and paste, but the original process where we did in the chambers, it will be there. And copy for service, you see, because this is on notice. So you have to write at the bottom and copy for service on the party. So what we have at the, bottom of the motion paper, you can also, not that you can, you must repeat it at the bottom of the affidavit as well. Good. Now, just before we look at the example of affidavit in opposition, okay, I said that in terms of writing affidavit, there's another style. So let me just illustrate that just quickly. So let me just copy this and then I will show you how. Okay, so the other one. So if you are following, good. So instead of doing it this way, instead of, I just a small thing I want you to, this is one style, one way of doing it. There's another way of doing it. So like all the things you said will still hold. But then when it comes to writing the body of the affidavit, so you say that I, Enrico Marinetti of House number so and so in the Central Region of Ghana, do make oath and say. You can say that, you can, instead of saying say as follows, you can say and say that, so that you delete the that here. Oh, sorry. Yeah, so in that order, so like you can also have it this way. I, Enrico Marinetti of House of so and so in Ashanti region of Ghana, do make out and say that I am the deponent. I am the deponent applicant and I'm the claimant applicant and deponent herein. Sorry. 2, the deposition I make, unless otherwise stated, are based on my personal knowledge, information, or belief. 3, my father, Enzo Marinetti, was the sole shareholder. So here, you had only one that in the opening instead of letting it run through. So as I said, there are 2 styles. If you want the that to run through, you are not wrong. If you want to have the that just in the opening so that you not run through, you're also not wrong. Okay? Good. So let's look at a sample of affidavit in opposition, not related to that case, because certainly we don't have that one. So affidavit in opposition, this is how it looks like. It's just the same thing like the affidavit in support. You have like the court, the venue, the Superior Court of Judicature, the High Court of Justice, Kumasi Ashanti, AD 2017. Then we have like the parte, Isaac Osei Safo against Martin Chebuzia and Akwesi Champon Padmon, and later on Good. So this was at in the running down action. The insurance company sought to join, and that is why we have end. SIC Insurance Company Limited applicant. So affidavit in opposition. Then the the part justice and so do make out and say as follows: that I'm the deponent here to and a clerk, a law clerk of the firm, solicitor for the plaintiff respondent. I have authority of the plaintiff respondent to depose to this affidavit on its behalf. That the content of this affidavit is, unless otherwise stated, are matters within my personal knowledge, information, and belief. I have authority of the plaintiff respondent to dispose of this affidavit on his behalf. There's a repetition. That at the hearing of this application, my counsel shall seek leave of this honorable court to refer to all the processes filed in this suit as if same were set out in this affidavit, in the census and so on to on oath. Now, this is where, let's say that, of course, if you can, instead of doing this kind of deposition, you can exhibit all the processes, but sometimes maybe a lot of them might have taken place, on the docket, and it may not be necessary for you to repeat everything. And since it's before the same court and with the same docket, and that is why you use this to lay the foundation, that at the hearing of the application, you seek leave of the court to make reference to some of the other processes already filed in the case on the docket. Now, those of you who practice, of course, you are still law students, you are not lawyers. But then, if you are a lawyer, the deposition in number 5 should not be used when you are dealing with practice before the Court of Appeal in the Supreme Court. Because the Court of Appeal in the Supreme Court, every application is given a fresh docket. So there's nothing like my lawyers shall seek leave to refer to all processes filed in this suit, as if same were set out in this affidavit and so on. There's nothing like that over there. But in the trial court, because the case has one docket throughout the life cycle of the case, you may make such deposition if needed. Says that I'm opposed to the motion as same is misconceived and without merit. So the number 6, for example, is not perfectly done. What motion are we talking about? So it should have just included, I'm opposed to the motion, so either motion or notice for interlocutory injunction, motion or notice for amendment, motion or notice for preservation. You should indicate it. 7, that paragraph says 7, 8, and all affidavits in support of the motion are denied. That same have been determined by the Honorable Court in separate applications, hence not relevant to the present motion to set aside the ruling on 9 December 2019 and costs awarded to the plaintiff respondent. So here too, if you look at this one, if not because of the deposition here in paragraph 5, okay, it's not because of the deposition in the paragraph 5, in which the deponent said that his lawyer shall seek leave to refer to processes filed in the suit. Paragraph 7 will have been inappropriate, so long as it has only alluded to certain proceedings or certain processes and have not exhibited them. So properly, they should have been exhibited, because here you are saying that same have been determined by the Honorable Court in separate applications. So we are interested in finding out the rulings from those applications. They should be exhibited. But because of paragraph 5, we may forgive the deponent and say that paragraph 5 will cure the apparent inadequacy of paragraph 7. And continue that paragraph 10 is denied, that paragraph 11 is denied, and in reply, I'll say that if indeed plaintiff counsel raised issues that require legal arguments, the Honorable Court as a court of record will have captured same for the record, which the plaintiff will have exhibited. 10, that paragraph 12 is denied, and in reply, I will say that it is scandalous to allege malice on the part of the counsel for plaintiff respondent without any factual basis, as allegation is borne out by the applicant's exhibit SIC1 attached hereto. 11, that paragraph 13 is denied, and in reply, I will say that the order for joinder is moot, as same had been granted by the court, hence not relevant to the present application, and same had also not been appealed or otherwise challenged via judicial review in the Supreme Court. Then he denies the rest. That I'm advised and very believe to be true that the applicant, the opponent per the rules, ought to have stated the source of her information, since she claims she was not in court, which at any rate is borne out by exhibit SIC1. The applicant deposed to hearsay matter, which are inadmissible and same should be expunged from his affidavit. That I'm further advised and very believe same to be true that the order given by the court on 9th December 2019 be an interlocutory decision ought to have been appealed against if the applicant, the opponent felt aggrieved by same. That our advice and very believe same to be true that the award of course in any proceedings the High Court is at discretion of the court, and the applicant has not demonstrated through affidavit in support that the discretion was wrongly exercised. 16, that I'm advised and very believe same to be true that the award of course can only be set aside by way of review or appeal, and so application is misconceived since the Honorable Court was seized with jurisdiction. 17, that I'm advised and very believe same to be true that the imposition of costs on the applicant by the learned High Court judge is to deter the applicant from unnecessarily absenting herself from court, and same cannot be said to be. If you look at 17, for example, 17 sin against what we are learning, isn't it? Because can anybody tell us why 17 is problematic? Why is paragraph 17 problematic? Based upon what we've been learning so far. Raise up your hand and I will release your mic for you. Why is paragraph 17 problematic? Whose hand is up? You don't see any problem with the paragraph 17 based upon what we'll be discussing so far. Are we together? Yes, Robert.
Hello?
Yes, Robert, proceed.
Yeah, my lord, good afternoon.
Good afternoon. Good morning, yes.
Yes, so if you read through paragraph 17 carefully, it seems to me the deponent is making an argument rather than stating the facts. Okay. And so it sends on the affidavit.
Okay, all right, good. Good. Yes, I think Pafano and then Mami Saba. You can release your mic. Now, 18, that since the High Court is a court of records, so that applicants' inability to attend court should have been communicated in writing to the court, which could have been exhibited thereto, or in the alternative, communicating to the adverse should have been given to counsel for respondent hearing. This is also sort of like an argument. It shouldn't have been done. That my advice and very believe same to be true, that the said ruling contains exhibit SIC1 and award of course that the applicant seeks to set aside are not void orders, for which the present application can be used to set aside. The orders the Honorable Court has jurisdiction to make. And the proper forum to vent any form of dissatisfaction is the Court for Appeal by way of interlocutory appeal, which has elapsed. That I would further advise, and very believe seems to be true, that this application is incompetent and same ought to be dismissed since the application failed to use the proper avenues provided by law to address her dissatisfaction on the said orders. Wherefore, I swear to this affidavit in opposition. Then you have like the place where the swearing took place, the deponent before me. Yeah, so that is how it was commissioned for commissioner for oath, and then the copies for service. Copied for service. The party. Good. So we will take questions and then move to pre-trial proceedings now.